What do you pay an employee who has been suspended from work for a reason which does not fall within the government's self-isolation advice?
Some of you will be aware that earlier this month the government changed the rules in relation to statutory sick pay, because at the time it wasn't capturing people who were trying to self-isolate as a result of being diagnosed or suffering symptoms from, or living with people who had been diagnosed or were suffering with symptoms from coronavirus. So those rules were changed, and we now have effectively two sets of guidance. We've got what's called stay-at-home guidance, which is the guidance that if you or someone who you share a residence with are diagnosed with or suffer symptoms from, then you have to stay at home for 14 days from the date the person first started to display symptoms. And that's an instruction effectively that must be adhered to. Then you've got what's called the social distancing guidance, which is basically the guidance issued to people who are deemed to be more at risk than others. So that's people who are over 70, pregnant employees, or people who are under 70 who suffer with certain conditions, for instance, asthma or the respiratory related conditions, motor neurone, and so on, that type of health complaint. So if anyone falls into those categories, then they are eligible for SSP. However, if it is possible for them to work from home, then allow them to work from home and they receive full pay. But if they cannot work from home, then they will be eligible for SSP. Now, it then gets a little bit confusing in my view, because we've now got this situation where lots of people are potentially self-isolating. Think that they might have come into contact with someone who has been diagnosed or displaying symptoms. The general advice on that at the moment is if somebody wants to self-isolate for those reasons, then they will probably be eligible for SSP. Again, unless they're able to work from home, in which case allow them to work from home and pay them full pay.
If a key worker goes home from work and does not have the coronavirus, where do we stand as far as paying the person?
Right. Well, that's similar to the previous question that I've answered. So, if they think they've come into contact with someone who has coronavirus, or they are starting to display symptoms, then it would be sensible to allow them to go home. And if they can't work from home, then unfortunately it's just SSP. And if they can, then it's full pay rather. If
Okay.
they are, sorry, a bit more, Bethany.
No.
Not like me, so you know that. If they are high risk employees, so if they suffer from a condition, for instance, asthma or something else which might amount to a disability, or if they're pregnant, then we wouldn't stop them from going home. We'd allow them to go home. And again, if they can work from home, pay them. If they can't, so pay them full pay. If they can't, then put them on SSP.
What can you do with an employee who refuses to attend work for fear of contracting COVID-19?
Well, obviously at the moment, with most people being compelled to work from home, this is an issue that we certainly had quite a few questions on in the run-up to Monday's lockdown announcement, and it may well be something that rears its head again once we hopefully get to the other side of this lockdown and enforced working from home period. So if somebody, can work from home, then as Russell said, it's always better to get them to do that. Better for you because they're obviously still undertaking work, and arguably better for them because they're going to still receive their full pay. If that's not possible, then you really need to think about three key issues. So what's the kind of current government health advice, and how does that relate to this particular person? What reason have they given for not wanting to come into work? Is it just general anxiety or fear or worry over potentially contracting the virus? Or actually, do they have some underlying health problems that would maybe justify them having legitimate concerns about attending work? You also need to be mindful, obviously, if they do have some sort of disability that may be very adversely affected by the coronavirus, be mindful of not discriminating against them, whether that be in the way of refusing any requests to work from home or taking disciplinary action against them if they refuse to undertake any work, or withholding pay. If, however, there's no discrimination angle and the current public health advice is that actually this particular individual, it's reasonable to expect them to come into work or to undertake some work whilst on this period of working from home. If they're unreasonably refusing, then that arguably is a failure to comply with a lawful instruction, which would be a disciplinary matter. And also, really, any period when they're unreasonably refusing to undertake work would really be an unauthorised absence, and you wouldn't pay them for that time either.
Where an employee falls into one of the categories the government has strongly advised to work from home, can the employer require them to come into work if their role cannot be carried out at home? And if not, do we still have to pay them?
I think the key issue here is we're talking about these more vulnerable employees, which Russell's already kind of briefly described to you. So those who are aged over 70, are pregnant, or are under 70 but have some serious underlying health condition that would be, severely affected by the virus. There are certain employers where, obviously, even in the current lockdown scenario, they're still able to operate. And obviously, those employees who can't work from home are permitted to still commute into work. Whether you would compel any vulnerable employee to do that, I think you'd have to be very careful, because obviously, as an employee, you've got a duty to protect the health and safety of your employees, particularly these more vulnerable groups of employees that may be on your payroll. And actually, if you were to try and compel them to come into work, you would be potentially breaching that duty, breaching the implied duty of trust and confidence, and therefore potentially opening yourselves up to possible constructive unfair dismissal claims and or discrimination complaints, because certainly quite a number of the conditions that the government has described within its social distancing guidance are very likely to amount to disabilities. Another point, I think, is if you do compel one of these vulnerable employees to come into work and they do unfortunately then contract the virus, you've also got potential liability from a personal injury perspective to be kind of mindful of as well. As regards pay for these people, in all likelihood, if they remain at home and they can't work remotely, they would probably qualify for statutory sick pay or contractual sick pay if that's relevant. The issue for people where they're exercising these social distance or they're complying, with social distancing guidelines is that can go on for several weeks, if not months, rather than people who are self-isolating for 7 days or 14 days. And you'll appreciate for people who are perhaps having to do this for several weeks or months, statutory sick pay is going to potentially place them in financial difficulty. Employers could consider offering, enhanced sick pay to these individuals, although obviously in the current climate that equally well may not be particularly attractive for employers. You've got this concept of furlough leave, which we're going to come on and talk about in a fair bit of detail, I imagine, in a short while. That may be a possibility, albeit really it's designed for individuals where you're at risk of having to let them go, essentially. Yeah, furlough leave may be a possibility, but I think we'd have to wait a bit more detail on that for these particular vulnerable groups.
Can an employee be required to take an annual leave whilst furloughed?
Right. The first thing I'm going to say about any of the questions relating to the coronavirus job retention scheme, or which we'll refer to as the furlough scheme, it's much easier, is we don't have all of the answers to everything at the moment. As we know, the government's trying to react to the situation as quickly as it can. It's laid out some basic rules, but we're experiencing, or we're receiving rather, lots and lots of questions about the detail, which we're still waiting to receive from the government. So a lot of the responses are based on what we anticipate will be the case in the coming weeks. So In relation to this question, can you take annual leave whilst furloughed? I don't see at the moment there being a problem with it, but there are potentially some risks. For instance, if the government somehow finds out that employers are treating part of the furlough leave period as annual leave and refuse to reimburse you as an employer. So where someone, well, basically the purpose of annual leave under the EU directive is to give you a break and a period of relaxation from work. Whereas with sick leave, the purpose of sick leave is to allow someone the opportunity to recover from an illness. And what the courts have said is that those two are kind of incompatible with each other. If you're off sick, you can't be on annual leave at the same time, because you can't be having a period of rest and relaxation if at the same time you're trying to recover and recuperate from a period of illness. Now, if you kind of apply that principle here, that ought not to apply, because if you're on furlough leave, then you can still have rest and relaxation. But then the counter argument to that is, well, do you need rest and relaxation because you've been furloughed? And of course, if you're furloughed, you're not allowed to work. So is it then morally or legally acceptable for an employer to be paying its staff annual leave and having them use their annual leave entitlement whilst they're furloughed at the expense of the government? So there's a risk there. You can ask employees to do it, and if they agree, then you potentially have the benefit of that annual leave cost being subsidised by the grants from the government. The risk is if the government somehow finds out further down the line or issues guidelines which say that any annual leave taken during a period of furlough leave will not be reimbursed. So it might be sensible to just wait a week or so until we've got some clearer guidelines, and then you can start to decide whether or not you want staff to start using annual leave entitlement whilst they're on furlough leave.
Can an employee cancel their annual leave if they are working from home?
You'll be pleased to hear this. The answer is no. Once an employee has submitted their request for annual leave, then it can only be withdrawn with an employer's agreement. And we've been asked this question, I've lost count how many times this week. The issue, obviously, for all business owners and employers is we don't want all our employees taking all of their annual leave in the second half of the financial year, when hopefully we're all back at work and we're trying to play catch up. So if a member of staff says to you, well, now I'm at home and I'm working from home, I think I need that period of annual leave, you're perfectly entitled to say, sorry, but the period of annual leave still stands. Probably from an employee relations point of view, it would be a good idea to give them your justification for that, because it is a perfectly legitimate and reasonable response to give to a member of staff. But in short, yes, you can say to staff, we're not agreeing to you changing or withdrawing your leave.
Is a worker who is in self-isolation entitled to reschedule their holiday?
Right, so for those individuals who have contracted the virus or have experienced symptoms, then yes, they should be entitled to reschedule that leave. It's slightly less clear for individuals who may be self-isolating because somebody they live with is self-isolating because they've either got the virus or they're exhibiting symptoms themselves. The whole purpose, as Russell explained before, behind annual leave versus sick leave is, to enjoy this period of relaxation, and sick leave is more to recuperate. So I think if they're not unfit for work, then there could be question marks around their ability to reschedule that leave. If you were erring on the side of caution, you may take the view that you would perhaps allow them to reschedule the first 4 weeks of their holiday entitlement, because the concept of allowing somebody who's sick during a period of prearranged annual leave actually arises from a Spanish case. And obviously that emanates from the European Court of Justice, and the EU leave provisions really only apply to the first 4 weeks of annual leave for UK employers. So if you wanted no risk, you'd perhaps, as I say, err on the side of caution and allow them to reschedule that first 4 weeks of leave.
What special considerations apply where the employee is pregnant?
Right, well, there is specific legislation in place which places an additional obligation on employers to protect the welfare and the health and safety of pregnant and expectant mothers. That, for those of you who are interested, it's the Management of Health and Safety at Work Regulations 1999. Basically, what those regulations say is that, first of all, you have to carry out a risk assessment, which is an ongoing process aimed at ensuring that pregnant, expectant mothers aren't put into a situation where their health or the health of their unborn child could be put at risk. If there are any risks which are identified, then you've got to look at putting alterations in place which would effectively remove those risks. If you can't remove those risks, then you have to look at some form of suitable alternative employment for that member of staff. And if you can't find any suitable, or agree rather any suitable alternative employment, then you have to suspend the employee on full pay. So you can see how that can be quite easily applied in these circumstances, where a pregnant member of staff might say, well, it's clearly in accordance with the government guidance, it's not acceptable for me to work within the workplace. What alterations can be made? An obvious alteration could be working from home. But if that isn't possible, and I can't really think of any off the top of my head, any obvious examples where suitable alternatives could apply, which wouldn't involve either working in contact with others at the workplace or at home. So if none of those do apply, then the likelihood is that you would have to suspend them on full pay until it was safe for them to return to work, or you could make some arrangements which would allow them to work from home.
What adjustments to absence management procedures will be required in light of COVID-19 sickness absence?
Okay, so I think the first thing employers need to be mindful of is the evidence of sickness that they are expecting their employees to produce. Ordinarily, obviously, we'd have self-certification for the first week and then a fit note from a GP. Where people are self-isolating, clearly it's not going to be possible for them to obtain the usual fit note. And that's why on the 20th of March, the government introduced a new scheme of isolation notes, which individuals can obtain to provide proof to their employer that, you know, they are unfit for work as a result of the coronavirus, whether because they've got the virus or they're exhibiting symptoms or some other reason. I think another issue we need to be mindful of is lots of employers' sickness absence policies will have trigger points. So when an individual's absence reaches a certain level, they'll then look to take informal and then formal action to address that sickness absence record. I think probably lots of employers will take the view that really it ought to exclude any periods of sickness absence relating to the coronavirus outbreak. Some employers may not want to do that. They may not want to have kind of a blanket policy whereby they disregard any absence related to COVID-19. I think if that's the approach you're looking to take, you do have to be mindful that if you've got vulnerable employees within your workforce, that actually some of them may, their disabilities, for example, could have resulted in them perhaps having to have longer periods off sick than people who aren't disabled have or would have, and therefore you may be at risk of potential disability discrimination claims in relation to those groups of individuals if you don't make some sort of concession or an adjustment really to reflect the impact their disabilities may have on their ability to you know, regularly attend for work, if you like. It may mean that they have enhanced rates of sickness absence as a result of coronavirus than non-disabled employees would have.
Can we refuse to allow an employee to work from home if they will also be looking after children who have been sent home from school or nursery?
Right, well, technically the answer to that question is yes, you can. Whether or not you choose to do that, however, in the current climate is a different matter. Initially, when the schools were closed, we received quite a few inquiries from clients who were saying to us, look, we've got members of staff saying they want to work after home because they need to look after the children, but the children are of such a young age that it's impossible for them to do any work. Why should they be looking after the children? Can't dad or the other partner look after the child? And the advice at the time was, well, look, if somebody's taking what's classed as emergency dependent leave, then you can't stop them from taking that leave, but it is a right to unpaid leave. So if you don't want them working, or you don't want to rather pay them for working from home because you don't think they'll really be doing a great deal of work, then simply say to them, look, we're not agreeing to that because we can't justify paying you because we don't think we'll get the necessary return, if you like, because you're going to be so occupied looking after your children. So by all means, take unpaid leave. That's not a problem, and that might persuade the employee to share some of that unpaid leave with the partner and spend some time in work. But obviously things have moved on since then, and the vast majority of us are working from home. Anecdotally from what we're hearing from clients we speak to and what we're experiencing ourselves, everybody's just trying to do the best they can. Businesses need to keep moving. If there's work that can be done, then employers want it to be done. We still need to do our best to keep, the money coming through the doors. So generally now you'll find that most employers' view is it's not ideal, but if I've got employees who can work from home and are willing to work from home, then we're going to allow that to happen and pay them full pay. And that just involves a degree of flexibility on the part of you as an employer, recognising the fact that employees are going to be working early in the mornings, late at night. They might be taking a few hours off during the day to do the Joe Wicks exercise videos on YouTube with the kids, make lunch, do homework, all the things that I've been saddled with doing for the last few days, and you get the work in between. But having said that, if it's not possible for someone to work from home, or the children are very, very young and you genuinely don't think there's little, if anything, an employee could do, then you would be within your rights to say, sorry, but no, it's dependent leave and it's unpaid.
Should we be considering layoff or short time working when we can furlough employees?
The answer to that is no, not really. Why would you? Not many employers have the ability to lay staff off or put them on short time working. If they do, then all employees are going to receive is payment for 5 days, and I think it's a maximum of about £145. As an alternative, we've got a scheme in place where the government is effectively offering a grant to employers to pay up to 80% of employees' salaries. So what that means is you can still send employees home. There's no additional financial burden to you as an employer. That's funded by the government, and you're helping support your staff. So I don't really see it. It's not morally right. I might be being a bit controversial there, but if you've got the means of paying your staff and you want to look after them, I would say that you ought to do that. But there is also the possibility of an employee saying, well, I appreciate you've got the contractual right to do it, but how can I have any trust or confidence in you as an employer where you've basically got the ability to pay me on almost full pay at no cost to your business, yet you are sending me home 145 quid. So it could theoretically give rise to constructive dismissal claims where employees just, aren't happy with the decision. And I don't think that would be an unreasonable take from an employee. If the employer was being expected to fund part of it, then that would be a different matter entirely. But at the moment, and I stress based on what we know, we're going to get under the job retention, then it would make sense to furlough anybody, even where you've got the right to lay them off or place them on short-time working.
Will it be unfair dismissal if I make someone redundant rather than place them on furloughed leave?
Yeah, I think there's certainly got to be a possibility of that for the reasons that Russell's just outlined there, really, that if you're making somebody redundant, then as part of that process, you're obliged to consider whether there are any suitable alternatives to terminating that person's employment on redundancy grounds. And on the basis the furlough leave provisions would allow you to place that individual on furlough leave and then still receive 80% of their salary with no additional cost to you, to your business, unless you choose to top up the extra 20%, then I don't think it would take much for an employee to try and run that type of argument if you ignored the furlough leave scheme and pressed ahead to make them redundant in any event. The whole idea behind furlough leave is to allow businesses to hang on to their employees, to see them through this rocky patch with a view to hopefully getting through to the other side. And when things pick up, you still have a requirement for that individual. Of course, if you don't at that stage, you may still face a genuine redundancy situation and could then proceed to make that person redundant. But yeah, I think for me, there's got to be risk from an unfair dismissal perspective if you just ignore the furlough provisions.
Can you force employees to take furloughed leave? And isn't it unfair to furlough some employees and not others?
Okay, well, first of all, you can't force an employee to take furlough. You are supposed to obtain their consent, but in reality, who wouldn't agree to it other than people who think they want to stay at work and continue to receive full pay? In 9 out of 10 scenarios where you ask an employee to be furloughed, bear in mind that you're supposed to do it where the alternative is that you would have to lay them off or make them redundant, then what's the alternative? If you refuse, you're going to be dismissed. So it's a no-brainer, really. So I don't really see there ever being an issue there with maybe just militant of employees saying that they don't agree. And if they don't agree, then the reality is they would almost certainly be made redundant. Excuse me. In terms of the selection point, well, yes, this is one of the questions that are posed to us quite a lot, which is we're going to have some staff who are unhappy at the fact that they're being asked to stay at work on full pay, whilst their colleagues are allowed to spend time at home with the children, doing the homework, etc., for 80% of their pay. Well, we've no guidance in terms of how we come to select employees for furlough leave. One obvious way is to invite employees to do it and then see how you're left in terms of numbers. But in practice, provided that you are exercising your discretion in a reasonable way in terms of who you choose to furlough and who you don't, then you won't have any problems. So if, for instance, you have key staff in a particular department that you need to keep them on, if they turn around and say, well, I'm not happy with that because my colleague's gone home, you just have to be straight with them and say, well, you're better equipped to do the job. I'd rather you be here. Yes, it's unfortunate, but that is, just the way it is. It's in the best interests of the business. We're trying to keep things afloat and as steady as we can until things are back to normal. And that requires you being here rather than your colleague.
Can an employer withdraw offers of employment or delay start dates for new recruits in light of the COVID-19 outbreak?
Yeah, so I think the key issue is whether the offer of employment's been accepted by the recruit. If it has, then you've got a binding contract of employment. So if you're wanting to withdraw that, you'll have to serve notice in accordance with the terms of the contract that's been entered into between the parties. In terms of changing start dates, again, you would need to really seek the individual's consent to varying their start date. Whether people would object in the current climate, I'm not so sure. You'd hope people would be quite understanding and flexible about that. You just need to be careful that if you've got a right to vary the terms of the contract within the written contract that's been entered into between you and the new recruit, be careful that you're exercising that discretion fairly, and that there's no sort of possible discrimination issues that could arise from pushing the start date back. But if it's purely and simply because you've just not got the work for them at the present moment in time as a result of this COVID-19 outbreak, then I suspect you would probably be okay, and you would hope most people would voluntarily agree to push their start date back a little bit.
It is not clear whether we can select a group of people now who have no work to do currently and furlough those people. And then if in the future if work diminishes further, we can furlough further people. Therefore, can we make multiple requests for different groups of people as and when they are affected?
The answer to that question is yes, you can. As I've alluded to before, the principle behind furloughing is trying to keep as many people in or receiving income as possible, and it's an alternative to making them redundant. So you can't. I don't think it will be acceptable to simply furlough everyone unless you can demonstrate that you would otherwise have to dismiss them as redundant. Quite how the government or HMRC are going to prove that is a different matter. We'll have to wait and see. But if we're going to do this in good faith and properly, if you have two departments, one is short of work, the other isn't, then you're perfectly entitled to furlough those employees who are facing a shortage of work who you don't need at the moment. And things change in the future and the other departments affected, then you can have another tranche of furloughing and place another batch of employees on furloughed leave. And that can go on and on. Because at the end of the day, you'll still need to keep running your business to a point, and then those skeleton staff will potentially get less and less as requirement diminishes. So yes, you can continue to furlough, say for as long as you like. At the moment, it's running from the 1st of March to the 31st of May, and then it's going to be reviewed by the government. But for the time being, yes, you can furlough people in batches.
During the furlough period, do employees still accrue annual leave? Do companies still make pension contributions? And if so, is that based on the 80%?
Yes, they still will. Well, we think they will still accrue annual leave because they're still employees. So just in the same way that a member of staff who's on maternity leave or on long-term sick leave, they continue to accrue annual leave. So I don't anticipate there being any difference there to a furloughed employee, because the idea is to remain an employee of the company. So therefore, it stands to reason they must still accrue annual leave. In terms of whether you continue to pay the pension contributions, well, that's one of the questions waiting for an answer to. So we know that it's 80% of salary up to a cap of £2,500 a month. We don't know what that salary will consist of, but there is reference to all employment costs used by the government in the announcement. So the expectation is that it will include everything, so the full remuneration package, including pensions, but we don't know whether that 2,500 is a net or a gross sum. I know there's been some speculation yesterday by the professional body for the chartered accountants, but unless they have a direct line to the government that no one else has, we're still a bit in the dark about that. I'm not saying they're not right, but we've not been officially told anything yet, so we'll just have to wait and see.
If we have a number of people at the same level, but only enough work for some of them, do we have to justify why we have selected one group of people to furlough and allow the other group to continue with the work that is still there?
Yes, I mean, that's similar to the question I answered earlier. If you've got what I think that is a reference to is if, for instance, you've got a department of 20 employees and you only want to keep 10 and you want to furlough the other 10, how do you go about doing it? Well, you're effectively exercising discretion if you're deciding who to furlough, and you have to exercise your discretion in a fair and reasonable manner, not in an arbitrary or capricious manner. If you do, then you're going to face complaints from employees and potentially complaints of constructive dismissal or complaints of discrimination if people are claiming that they're being selected for reasons such as their health or their nationality or their age. So there's no hard and fast rule. You've just got to have some sensible, logical justification for why you're furloughing some people and not others. So maybe don't furlough people on the basis of their attendance. Some of those absences are disability related. You could something similar to a redundancy selection process, because you'll probably want to keep the best employees. You might want to keep those where it's the most financially advantageous. Don't see anything wrong with that. You need to have a reason so that if it's challenged, you've got something to fall back onto.
I am assuming that you have to 100% furlough an employee as they are not allowed to work. If, for example, you can't ask them to work 50% of their time and furlough for the remaining 50%. Is this correct?
It is correct, yeah. Once you're furloughed, you can't work. So you could be, I suppose you could theoretically be furloughed for 3 weeks and then called back into work because there's a demand for your services and then furloughed again. But what you can't do is furlough an employee and then ask them to do bits and bobs of work at home. That is probably one of the top 5 questions that we've had in the last few days. If I furlough workers, they can do a bit of work, can't they? Well, the answer to that is, strictly speaking, no, they can't. Practically speaking, not quite sure how that could possibly be policed. HMRC have indicated that they will take action against anybody who tries to abuse the system, and I'm sure they will try to publicly shame them in the same way that they do with respondents in tribunal claims nowadays who don't pay the awards of damages that they're ordered to pay by the tribunal. But I think it's going to be very, very hard for anyone to police that. But strictly speaking, if you're furloughed, you're not allowed to do any work at all. And I would say, from an employer's perspective, you ought to make that clear, because there is the possibility that some employees just can't help themselves and will want to check their emails and maybe try and do things with their colleagues to keep on top of things, which could land you as the employer in hot water. So a clear instruction that you mustn't work would be well advised.
Can you furlough directors?
I don't see why you cannot furlough an executive director. You can't furlough a non-executive director because they're not an employee. But the guidance we've had says that you can furlough employees, and executive directors are employees. So no harm in doing that from what we can see at the moment.
Will the employer be liable to pay the 80% to their staff and then be able to claim it all back at a later date?
Yes, as we understand at the moment, a bit of speculation here, but we can't really envisage a situation where anyone other than the employer would pay directly to the employee. And from some of the some of the commentary I've seen, there's reference to payroll through the real-time information system, which suggests that the employer is going to be paying. In fact, to be fair, a lot of things point towards that. So the employer will most certainly, with 99.99% certainty, be paying the employee directly, and then they will claim it back from HMRC via this portal that they said they're going to build. The government has said, or HMRC have said, that they hope to start making payments in the next few weeks, but then I've also seen them say somewhere that they hope to have everything up and running by the end of April. So that doesn't quite sit. I don't see how they can start paying things in the next, reimbursing employers in the next 3 weeks if they're going to have the portal set up until the end of April. Those are the scales we're told we're looking at the moment.
Do companies have to pay furloughed employees the extra 20% of their salary?
No, you don't have to pay the extra 20%. All the wording and the guidance we've received so far is optional. Something you need to be mindful of, though, is if you're not paying the additional 20%, employees will obviously only be earning 80% of their usual wage. So you would need to get their express agreement to that at the point of time at which they're agreeing to become a furloughed worker or a furloughed employee. If you don't do that, then you're at risk of them potentially turning around further down the line and trying to argue that there's been an unlawful deduction from their wages for the period they've been on furlough leave, where they've only been receiving 80% of their usual salary.
Has there been any information on how long companies will have to wait before they receive the grant? So sort of once the portal's been set up to them getting sort of money in the bank?
No, not yet. It's the point I was making before, that we're told, they've said they're hoping to get payments out within the next 3 weeks. But the portal, I've seen it mentioned on the guidance website that it is end of April. So we'll have to wait and see. What I would say, excuse me, is this: I can't see the government delaying too long, because most employers are in a position to indefinitely pay employees' salaries when they've got little coming in terms of income. And if the government leaves it too late, it's going to defeat the whole purpose of what they're trying to achieve. So I'm sure they are looking at it as we speak. I know there's an announcement apparently going to be made this afternoon, fleshing out some of the rules for self-employed freelancers, and I would imagine as we speak, they're looking at what they're going to do with employees, so we'll get some clarity very, very soon.
How can companies continue to follow a fair process during a period of lockdown in cases of gross misconduct, capability dismissals, in regards to either those currently being progressed or should any new cases come up?
There's nothing which says that you can't conduct a disciplinary or a performance management meeting remotely. It could be done through Skype, through Zoom. That still involves a fair process. It's going to involve making sure that the individuals have all the relevant information in front of them so that they have time to prepare for the meeting. But in the current circumstances, we might not have any choice, because we don't know how long this is going to last. And I think it would be unreasonable to expect employers to sit for disciplinary and performance management related matters indefinitely. It might, however, be an issue in that performance issues will inevitably arise, but they might arise for different reasons. For instance, the fact that more people are working remotely and it's harder to do the job. And I think that's going to have to be taken into account, because tribunals are going to have sympathy for employees who are struggling to carry out their job in the normal way because of them working remotely. So I think we'd need to be careful about that. In terms of those which are currently being progressed, my advice would be to get on with them. Could technically still arrange to meet up with employees to do them. There's nothing in accordance with the government's guidance which says that you can't do that, but if they're in the high risk category, then I'd probably advise against doing it. But you can guarantee at the moment you invite someone to attend a disciplinary meeting, they're going to suddenly start coughing and telling you that they've got hot sweats and they're too unwell to attend. But worth a go. Everything's up in the air at the moment, but I would say over time systems will be put in place, and I would expect to be advising lots of clients to deal with disciplinary matters remotely via the various software that we've got available to us now, like Zoom and Teams and Skype and so on.
How should companies handle any potential reduction in staff numbers due to the loss of business and revenue, should this situation go on much longer than hoped?
I suppose the point is this, the coronavirus job retention scheme means that we don't have to address the issue of staffing numbers necessarily at this stage, because the government is going to provide that security where we don't have to incur the staffing costs. I have had discussions with clients, however, where they know that they are not going to need the same number of employees once we're all back into work. For instance, certain forms of manufacturing, because production's going to drop because there'll be a reduced demand for certain products. So potentially furloughing staff buys you time to start preparing your redundancy plans, particularly given the numbers that we could be talking with some employers, without sounding too negative, will be in the 20 redundancies within 90 days situation, which is going to involve triggering the collective redundancy rules, which are far more complicated. So now is the time to start looking at that. But ultimately, my view would be you can keep your employees on furloughed leave as long as reasonably possible. Hopefully it will be, well, hopefully it won't be necessary beyond the 31st of May, and we can start to get back to some form of normality. If we can't, then the government has said they'll keep it, they'll review it at that stage, and hopefully they'll extend it for as long as necessary. Again, not wanting to be too pessimistic, but quite how long they can continue to pay 80% of salary up to a cap of £2,500 is anybody's guess, but we'll just have
advice or guidance on home working rules, expectations, behaviours, and monitoring or managing any poor performance abuse of this provision. Do you have any guidance you can give companies?
Well, you should all have a policy in place, a home working policy in place. That's the first thing I'd recommend. There are then some recommendations that you can make. Some are a little less practical than others. You're supposed to carry out a health and safety risk assessment of every employee's workplace. I normally get people sniggering at me when I suggest this, but technically, if you've got employees working from home, then you need to carry out some sort of informal risk assessment, or get them to do it and confirm that they've done it. It's hard to imagine what risks could be posed at home, but I suppose loose cables, overloading plug sockets, that type of thing, but I don't think it would take very long. One obvious factor to consider, though, is GDPR and data protection. You will potentially have employees processing a lot of personal data on behalf of the business relating to customers, employees, outside of their normal work habitat or environment. We have to have special measures in place to protect this or preserve the security and the integrity of that data under the GDPR. So employees need to be made aware that they have to comply with those obligations. That would probably involve, again, carrying out some sort of assessment or analysis by an employer to make sure that laptop left switched on near windows, if documents are printed off on a home printer, or if they're being brought home, they're not thrown away when they're not used in the normal waste recycling bins outside, that sort of thing.
If a company has suspended its business activities, is there a requirement for employees to report their sickness, whether diagnosed with COVID-19 or not, either at the time or upon return to work?
I think that's a little bit like the point I made earlier about, you know, it's not possible to get a normal fit note now, but they can get an isolation note, which would authorise their absence if they're diagnosed with COVID-19 or suffering from appropriate symptoms. For other individuals, I guess you may already have a system in place whereby they phone an absence line and leave a voicemail or send a text message. I think it's thinking about ways that you can still have that function where everybody is perhaps working remotely. So I guess you would still want people to be reporting in where they're sick, whether it's related to coronavirus or not. It's just thinking about the most appropriate way for employees to do that. Maybe you already have a system in place that functions perfectly well when everybody is working remotely, but if not, you may have to have a think about how you envisage people can report going forward when everybody is currently on this lockdown.
Do you have any advice or guidance on managing key workers or on-call workers for emergencies?
I'm assuming what is being referred to there is a scenario where you need employees to be kind of on call for certain situations. Trying to think, for example, an alarm goes off in the offices or the business premises and someone has to go out and deal with, for instance, I don't know, a facilities manager. Well, technically, you are still allowed to operate your business. The guidance is if you can work from home, you should work from home. That may change at some points in the future. We don't know. But provided that you are not putting an employee at risk by asking them to go out to an emergency, provided, for instance, that they don't fall within the high risk category of individuals where they're over 70 or pregnant or suffer with a particular condition that puts them more at risk or susceptible to COVID-19 than someone else, then I don't see a problem with that. These carry out a risk assessment and speak to the individual. Obviously, if they're unwell or they're self-isolating because they're living with someone who's got the condition, then that wouldn't be possible. But otherwise, I think it's theoretically achievable, just with a bit of common sense.
What about employees who have already been given notice of redundancy or placed on unpaid leave before furlough leave was announced?
Well, the government's confirmed that furlough leave will all be backdated on the 1st of March. So, in principle, if you have somebody who's working their notice with a view to terminating on grounds of redundancy, or they've agreed to be placed on some form of unpaid leave, in principle, you could approach them and put them on furlough leave. I can't imagine for the life of me that most people would object or refuse to do that. It's slightly more complicated if somebody's employment's already terminated on redundancy grounds. You know, the kind of public policy reasons behind the furlough scheme is to help keep as many people in work as possible. So it may be possible that you could reinstate, re-engage somebody and place them on furlough leave. But I guess we'd have to maybe wait for a few more details on the scheme for that. But I think in principle, it could certainly be possible.
Can you move employees who are already on reduced hours onto furlough leave?
I think really you'd have to be thinking about why you would be doing it. So if actually you're coping okay with people working reduced hours, then arguably you may say it's not really a case to put them on furlough leave because it's designed for when, you know, the alternative is layoff or redundancy. That being said, whether the revenue are really going to investigate and delve into the detail behind specific furlough requests remains to be seen, although, as Russell alluded to before, the government's business support guidance does suggest that they will have powers to retrospectively audit employers. So yeah, I think for me, I think it's possible, certainly if you've reduced somebody's hours with a view to trying to keep things going, but you're now at the stage where even that isn't enough and you are genuinely contemplating layoff or redundancy, then furlough leave would be applicable in those circumstances.
Are you allowed to furlough a new starter who hasn't commenced employment but has had an offer of employment?
Well, no, you wouldn't furlough someone who hasn't started to work for you yet, because there's no obligation, obviously, to pay them any wages until they've started. You could tell them now that when they are due to start, you would like to furlough them if you don't have any need for their services. I don't see any problem with that at all. I think it was touched upon earlier by Sarah. One of the questions was, you know, can you withdraw offers or delay start dates? Yes, you can do all of that with consent. You can withdraw offers by giving notice. But it seems to me the sensible thing to do would be to allow the individual to start so they have some security, and then you can decide further down the line whether or not you still require their services.
What do we do with 0 hours workers?
The answer is, at the moment, we're not entirely sure. The guidance does refer to individuals becoming furloughed workers, which leaves the door open, I guess, to 0 hours workers running an argument that really it ought to extend to them as well. Again, like I said before, the public policy reasons behind furlough leave is to try and keep everybody in work, which may sort of lend weight to the suggestion that it really ought to extend to 0 hours workers. But the flip side to that, of course, is the whole, or largely the reason employers engage 0 hours workers is so they can control whether they offer them any work or not. And in times like this, they can take work to offer you. I suppose if you were being very cautious, you may take a view and decide that, you know, you were potentially going to put them on furlough leave, for example. But I think the devil will be in the detail, as with all of this. So I think at the moment it's a possibility, but we're going to need some more clarity on this, really.
Do employees have the right to be notified if a colleague or a customer develops the virus?
Yes, they have a right to be notified. They should be notified. My understanding is that the NHS England and Public Health England advises that if someone is diagnosed, then you have to inform people who they've come into contact with. What you can't do, though, is inform employees the identity of the colleague who has been diagnosed. Quite often they'll know anyway. You can obtain that individual's consent, and one would hope that most individuals won't have any problem with that. But if you don't have their permission, you can't disclose their sensitive personal data for GDPR purposes. The main topic, or the main source of questions at the moment, is obviously furlough leave. Everybody wants to know about it for understandable reasons. What we know is fairly limited at this stage, but we do have the basics, obviously, that there is going to be that payment made of up to 80%. We're keeping an eye on things. We're trying to get information out to you as clients as quickly as we possibly can. We're trying to do that in the form of the Q&A document, which most of you will have had, and through other email bulletins or briefings that we're trying to send out. If you've got questions, then by all means get in touch with one of us, and we're happy to try to answer them. But as soon as there is any movement from the government on furloughed worker status and the detail, then we'll be getting something out to everybody. There've been quite a few additional questions, by the way, that we've received late this morning that we haven't been able to cover because we knew we wouldn't have time to go through them. So those people who have submitted those questions, we will contact you later on today to have a chat with you and hopefully provide you with some answers.